Yes.
Good morning. Will it please the Court? In this matter, I appear on behalf of the appellants, together with my learned friend, Mr. Philip Steer. The trustee respondent to this appeal is represented by Mr. Brian Green of King's Counsel and Mr. Edward Sawyer.
Yes.
With your, with the Court's permission and indulgence, what I propose to do in terms of structuring my submissions it is to deal initially with 6 relatively short headings before turning to the individual grounds of appeal. And those headings are as follows. First of all, the case and its context. Secondly, the relevant provisions of the RPS. Third, the protection order and the statutory scheme. For the Railways Pension Scheme RPS scheme design, why was it created as it was? 5, I shall briefly mention the claim form and the issues, but that won't take very long. And 6, I shall deal with some points on the Chancellor's decision and the appeal before turning to the individual grounds. I hope that, at least as an initial starting point, is a structure that will work. First of all, the case and its context. And by the context, I include a number of things, but one of the things that I include is why we are here at all in this court on Part 8, when in the background there is a dispute in relation to unresolved actuarial valuations of this section of the RPS shared cost arrangement involving the pensions regulator. But first, let me please deal with the nature of the RPS SCA sections. They are, and this appeal concerns those sections as the vehicle for the accrual of pension rights post-privatisation of the railway industry in 1994. The predecessor to all of this was the British Railways Pension Scheme, BRPS, with its government backing at the time of the nationalised rail industry. The RPS is within which the shared cost arrangement section is part, and as a subset of the shared cost arrangement section, there are a number of individual sections, of which the Atos section is one. Although we are concerned on this appeal with matters relating to the Atos section, there are a number of other sections out there, indeed quite a considerable number. The Railways Pension Scheme is a creature of statute. The key pieces of legislation are the Railways Act 1993, the Railways Pension Scheme Order, which had the trust deed and rules for the shared cost arrangement attached to it as a schedule, the Protection Order, and to give it its full title, the Railways Pensions Transfer and Miscellaneous Provisions Order 1994, but that's the transfer order. Now, first in time was the Railways Act, and within that, Schedule 11 is the relevant part. There's an awful lot in the Railways Act 1993. You only need to consider Schedule 11. It is Schedule 11 that gave the Minister powers to make the statutory orders that then followed. The RPS order, as I call it, with the trust deed and rules attached, and the protection order, both promulgated at the same time by the same minister, with effect from the 31st of May 1994. They essentially set up the shared cost arrangement and other elements of the Railways Pension Scheme. As I say, the shared cost arrangement only being one part of a broader whole. Essentially, the shared cost arrangement was intended to take those who were active, in broad terms, those who were active members of the British Railways Pension Scheme as at the effective date, which was in October 1994, when the transfer order, which I've mentioned already, came into being and had the effect of transferring the assets and liabilities from the British Railways Pension Scheme to the RPS.
And the pensioners had a different situation, and they had a cast iron guarantee.
The pensioners went into, I think, Section A of the Railways Pension Scheme, and the deferreds went into Section B. Clearly, they were both closed. There were no employers in relation to those sections, and to use the word of the minister, the minister, the Secretary of State, effectively stood as proxy for the employer, and there was a government guarantee, which we'll come to. We'll have to have a little look at that in due course when we deal with Article 7 of the Protection Order. But my lady is completely correct about that. So we're, as I said at the beginning, that we're concerned with the section that was the vehicle for ongoing accrual of pension rights. Next point, the construction of Rule 21 of the Atos shared cost arrangement is the main task for this court, in my suspicion, as you will no doubt have picked up from the skeleton argument. There are some issues relating to the protection order, Article 7 and Article 5, but the principal task is to construe, in the appropriate way, Rule 21 of the section. I want to just make, at the beginning, a few very brief points about what we say is the basic structure of Rule 21, to flag it up at the beginning. I'm only going to say it in summary form, and I'll come back to it in more detail. It's Rule 21, we say, is a particular form of historic rule addressing a particular type of specified shortfall, which is described within the rule, with a particular remedy for, quote, making it good. That was inherited from the pre-privatisation British Railways Pension Scheme, not in identical terms, but that basic structure it was inherited from the BRPS. It's probably, that is Rule 21, sui generis, but its main components reflected a kind of approach to pension scheme valuations at that time, and indeed in theory at this time too, but much less commonly nowadays, a different approach to the past service deficit valuation approach, now universal, at least in applying the modern day statute requirements in Part 3 of the Pensions Act 2004.
You'll have to bear in mind, Mr. Spink, not the first time, that I'm not a specialist, and in the last half a minute you've taken to using trade jargon, which I can't follow.
I'm going to try and explain more clearly, if I may come to it, because I'm trying to give you the headline.
Certainly.
And if I can trespass on your patience for a while, it will come, I think, more clearly later on.
That's fine.
The second point in this little section dealing with the structure of Rule 21 that I want to make is that the specified process for making good the kind of shortfall described in the text of 21.1 to the fullest extent possible requires the use of specified tools, if I can call them that, the sequential application of which to the fullest possible extent, we say, was and is mandatory. Those tools are, in a real sense, we say, scheme redesign tools requiring first of all, a change to the amount required to be contributed through the specified 60-40 shared cost contribution structure specified in Rule 3, which is the contribution rule that works with Rule 21. That change usually, and in this case, in the circumstances in which we find ourselves at the moment, undoubtedly would have to be an upward move in the amount required to be contributed, which has a ratchet effect, carrying forward that increased combined employer and member burden, 60-40, indefinitely, subject to subsequent amendment. And secondly, in characterising these as, in a real sense, scheme design tools, if required, a reduction in active member future service benefits, potentially to zero. In other words, potentially under the rule, reduction of benefits going forward was part of the tool to deal with the shortfall, the particular kind of shortfall that Rule 21 was addressing. That was a potential tool under the BRPS, not in quite the same way, because under the BRPS relevant rule, Rule 45, benefits could be reduced, both accrued benefits retrospectively and future service benefits, but only by an agreement between the employer and the trustee. Absent such agreement, the only way under the BRPS to deal with a shortfall of the type being described in Rule 45 of the BRPS was to increase the contributions, the combined 60-40 contributions with no cap in order to meet that shortfall. That built in to the BRPS, and to an extent it's been carried over into the RPS, the possibility that under the BRPS, members might share 40% by way of contribution of a very significant amount if the shortfall was very significant. And as active members leave the scheme and the number of active members goes down, the number of them to share that burden, which doesn't just relate to their own benefits, it relates to the benefits of everybody in the section, pensioners and deferreds. There's a historic liability that has to be met, and if there are not insufficient assets to do so, looking forward to the income stream that will come in due course, then that's a shortfall that will have to be made good, and the route to that under the BRPS was, as I say, potentially an agreement to reduce future service benefits, but otherwise an unlimited increase in contributions.
45.5 is increase in contributions. Where in 45 is reduction of benefits? No, don't stop now. But I'd just be grateful to know.
It's in the it's in the preamble, I think.
Okay.
I'll take your leadership to that in due course,
Don't worry.
if I may. I don't want to get too deeply into this right now.
Exactly.
I'm trying to give you an overview. Next point, and I've given you my little potted view of how we say the rule works in very simple terms. Next point, Rule 21 concerns a part of the triennial actuarial valuation process called for under the rules of the section. There is also now a statutory overlay on that, but under the rules, triennial valuations more or less are required, and as part of that, an assessment of the shortfall, or indeed the surplus, if there is one, under Rule 20, but more likely the shortfall under Rule 21 is part of that valuation. Another important part of the context is that in 1994 there was a limited amount of statutory intervention in pension scheme actuarial valuations. Very different from nowadays. Relevantly in the form of the Disclosure of Information Regulations 1986, which stipulated that trustees must get actual valuations, when they must get them, what they must cover, and in conjunction with professional guidance binding on actuaries, how they must be prepared. Although those guidelines did not in themselves make it obligatory for the actuary's advice to be followed. In 1994, something called the Good Committee had reported looking into occupational pension scheme funding and potential reform post Robert Maxwell. And the Pensions Act 1995, with its minimum funding regime, was around the corner at the time this scheme came in. It was enacted in the 95 Act, only became effective from the 6th of April 1997.
Before we go any further, I know you're just giving us an outline, but all of these things, do you say that they are directly relevant to construction, or are you just educating us?
I'm giving you some context, and I'm partly...
That's why I'm asking, what do you mean by context?
I'm partly educating the court.
Thank you.
If I can be so bold as to presume that I might be able to do that.
Certainly, you're not being bold in my case. And you said this was by way of introduction. So
yeah.
That's fine.
The key point about the construction task with which this court is now faced is that the court needs to construe the rules, Rule 21 principally, without taking into account the statutory assistance that now applies in the form of Part 3 of the 2004 Act. And one of the reasons for giving that little potted history and making that particular point is that, pausing there, we say the court should strive to avoid anachronism here. In construing Rule 21, we need to set aside the intellectual baggage which comes from nearly 30 years of statutory funding and construe the rules in their own terms. For example, don't assume that shortfall in Rule 21 means funding deficit, as you've come to understand that term, or one has come to understand that term from other more modern sources. My next point is that the dispute between Atos and the trustee arises in relation to actuarial valuations as at 31st of December 2016 and 31st of December 2019, both under both the scheme rules. That's the rule that we're talking about, and Part 3 of the Act, the 2004 Act. Now, those valuations are way overdue. The Part 3 valuation at the former date should have been settled by the 31st of March 2000 and later, and the latter by the 31st of March 2021. The regulator is involved because the trustee and Atos have not been able to agree. Because TPR, I apologise, my lord.
Pensions regulator.
Yes. That
Even I know.
far too easily off the tongue. But if I can say TPR, it'll save me a precious second every now and then. Could I invite the court to take a quick look, please, at the letter to the court below from the regulator at Bundle B, tab 16. This arose because the regulator is in the middle of, or was in the middle of, conducting an exercise because of the lack of agreement between Atos and the trustee to consider how to exercise its statutory powers under Section 231 of the Pensions Act 2004, and they agreed in consultation with the parties to this Part 8 that certain questions, not questions relating to Part 3, but questions relating to the construction of Rule 21 should be decided by the court under Part 8. You can see from the fourth paragraph that the regulator currently considers that the present Part 8 proceedings issued by the trustee are the best forum to resolve the issues that have arisen between trustee and Atos. Accordingly, the regulator has not issued a warning notice preliminary to exercising its powers under Section 231. It had been threatening to do so, but it held off because of this. You can see in the next paragraph a hope on the part of the regulator that the result of this proceeding may mean that they don't have to take any action, but that's clearly not certain. And very important, the final paragraph on page 242, the operation and meaning of Part 3, etc., are not issues within the scope of the Part 8 proceedings. The regulator was very keen to ensure that all questions relating to the interaction between Part 3 and the scheme rules should be left over for them to consider their position once the court had told them how Rule 21 should be construed. And one of the key points in that exercise is whether or not the correct operation of Rule 21 changes or should have the effect of reducing members' benefits. It also has the effect potentially of putting up their contributions. But knowing what the benefit structure is, if I can put it that way, is an important piece of background information for the regulator. I will summarise the position only this way to say that the law on the interaction between Part 3 and rules within a scheme is not straightforward.
And we're not concerned with it.
And you're not concerned with it. But,
which is a blessing.
But that explains why, in a sense, this is perhaps a preliminary issue to the ultimate resolution of the funding issues that there are between the parties. And what the Court of Appeal in this case decides will not determine the outcome of the ultimate commercial question, which is how much the companies, Atos, are required to pay by the regulator. That'll be answered in stage 2. Finally, I was going to explain what shared cost as inherited from the BRPS and carried over into the RPS means, but I've said it already, 60-40, not fixed employee contributions.
And it was 60-40 in the BRPS? It
was.
45.
Yeah, right from the very outset, it was 60-40.
And just in the briefest outline, what powers does the regulator have under Section 231 of the 2004 Act?
Well, for example, the regulator can impose, absent the parties having agreed it, something called a schedule of contributions, which will set out the contributions that have to be paid to meet the deficit, the funding deficit, which is a past service reserve deficit. Somewhat different, we say, from the shortfall that Rule 21 is concerned with, but it's all part of feeds into that package. And to the extent that there is a past service deficit, also what's called a recovery plan, which is the payment by the employer of deficit repair contributions over a particular period that will have to be decided, and that the length of that period is very important to both the regulator and the trustee and Atos, because the shorter the period to repay a substantial deficit, the higher the annual contributions will be. And that's in some form or another, that's the likely ultimate outcome. Once it is known to what extent, sorry?
I'm terribly sorry. I mean, if the trustee holds this appeal, then the liabilities will be as established under the rules and the protection order, and the regulator will abide by that and will only fill the gap to the extent that complete recovery is not made under the rules and protection order.
I'm not sure I was conscious of saying anything different, but thank you for explaining it in the way that you have. Yes, another power that the regulator has is to cease accrual. That's within its suite of powers. The other key characteristic of the shared cost regime under the BRPS carried into the RPS was that it's not just limited, they were not just limited to increased contributions, but to what has been called benefit flex. I'm not sure if that's the best word for it, but the ability to change benefits going forward to contribute some value to the shortfall that needs to be made good. In that sense, it's not like some defined, indeed many defined benefit schemes where there is an amount sometimes payable by members with a broad balance of cost covenant and obligation on the employer to sweep up the rest. That's not the structure that was present here or is present here, subject to the effect of the protection order, of course, and the characteristic of reducing benefits in order to contribute to the shortfall is a particular feature. It doesn't stop it being a defined benefit scheme for the purposes of the statutory regime, albeit that it's a slightly unusual one. Next heading, the relevant provisions of the Railways Pension Scheme, and I just want to flag up very few of these, if I may. First of all, clause 6b, please look at B12, page 12. This is the pension trust of the RPS as at the 25th of November 2021.
As at the 25th of November 2021. Thank you.
Yes. This is the up-to-date version of the pension trust. The original version annexed to the Railways Pension Scheme Order 1994 is in tab 4 of the bundle. I don't propose to take you there, but that's when the RPS was created, the trust and rules that were attached. That was in May of 1994. There were amendments by the time it was actually up and running pursuant to the transfer of assets and liabilities in October. There had already been some amendments to it. Atos came on the scene some years later and adhered as an employer to the RPS SCA, and the current trust, as I said, is at tab 12.
I think that Atos is predecessor adhered in 1997,
Yes.
but I don't have the date when Atos did. But please don't stop now, but I'd be grateful for it.
Thank you. We'll get that date for you, lady. The clause 6 is to be found on 6B is to be found on page 182 of this bundle. And the relevant paragraph is on page 183. The trustee shall comply, it's the second paragraph, with section 224 of the 2004 Act. The trustee shall obtain actual evaluations of not more than 3 years from the date. Now, in the original version, obviously there was no reference to section 224, the intervaluation dates were slightly different, but other than that, it's the same in principle. The employer can seek an out-of-sequence valuation, but as you will see in due course, the overlay of the protection order in this case triggers the requirement to undertake valuations in addition sometimes to the triennial valuation.
But it's also of note, isn't it, on page 183, immediately under the paragraph that you referred us to, that the actuarial valuation should be drawn up in such a way as to enable each section to be considered separately, but then before preparing the valuation, the actuary shall consult with the trustee, the designated employers, etc., and the pensions committees
correct.
as to basis, methodology, and assumption. So that gives you a sense of what the actuary is doing.
Yeah, exactly. Thank you, my lady. The contribution rule is in the rules at tab 13. It's rule 3. You'll see it split into two parts, 3A, which you can see at page 207, which are the employer's contributions. And you'll see here the shared cost structure appearing, because subparagraph 1, each participating employer shall contribute at a rate determined by applying the multiplier of 1.5 to the amount contributed under Rule 3B by members. There are quite a lot of slightly complicated surrounding provisions, but that is the basic structure. And I think it's better to keep it simple for the purpose of this appeal and not look at all the other particular types of additional contributions that might be payable. Nothing turns on them. And you'll see on page 211.
Before you go on, sorry to be such a nuisance. Sub-rule 1 of 3A says it's subject to Rule 21. Same, for example, appears in 3.
Yes.
So this is all intended to be dovetailed.
It is indeed intended to be dovetailed.
I'm sorry, Mr. Spink, you were going to?
I was just going to take you to the normal contributions by members. So this is the basic unit, if you like. The members' contribution is worked out, and you can see at 3BA that at this time it was a function of something called the Future Service Joint Contribution Rate. And I'm not going to complicate matters or divert us by trying to explain what that is about, but it is effectively the rate required on an annual basis to fund the liabilities of the scheme, and it's
It might be of some relevance to know who fixes and how you fix the future service
that's
joint
fixed by the
contribution rate.
actuary.
Fixed by the actuary. Would somebody provide me with the provision so that I can look it up?
Yeah, sure. The definition, page 2. I think that's the one. 201.
201.
That tells you that, as you will have appreciated, my lady, there is a helpful, lengthy definition section at the beginning, and if you go to page 201, you'll see it's the normal long-term funding rate of the section as determined by the actuary from time to time.
So yes, again we have the use of the word determined there.
Yeah. And then if you go to page 218, by way of preview, you can see the bottom of page 217 is Rule 20 surplus assets, and that speaks of an actuarial valuation revealing a surplus, and you'll note that the surplus is one that consists of a positive balance in favour of assets, but the asset side of the equation is the section assets, current assets, together with future income and future contributions due under Rule 3 and Rule 4. And that is the same approach as Rule 21 to the calculation of surplus or shortfall. In other words, it looks at the position of the scheme, not by reference only to a past service surplus or deficit, which is the conventional approach under an accrued valuation method, and on top of which there would conventionally be an assessment of what future contributions will be needed to meet the future accrual that will occur in the future. And and those are two separate elements in the conventional approach. What this is doing is lumping together current assets, current liabilities, future assets and future liabilities. And you can see that clearly in Rule 21. Where if an actuarial valuation of the section by the actuary shows that the section assets together with future income and future contributions are unlikely to be sufficient to provide the benefits for members, etc., then paragraph 1 below shall apply. So, if we look at this version of the rule, there have been changes to get to where we see now, and it may be necessary to explain some of those amendments to you as we go along through the case. But just to give you the structure, you will see that a valuation is undertaken by the actuary if it shows a shortfall of the type described in the opening words of 21(1), and it's become conventional in this case, and the Chancellor in his judgment below adopted this convention to refer to the main paragraph as 21(1) stem.
Yes, very useful.
And then we have 21(1)(1), 2, 3, and 4. If that valuation reveals a shortfall of the type described in Rule 21, then unless the designated employer and the trustee agree within 6 months of the signing of the valuation arrangements, so the actuary has done the valuation, made the necessary assumptions to do it, and worked out whether there is in fact a shortfall, unless they agree arrangements to make good the shortfall shall be made good in the following way. And then we come back to more detailed submissions on this in due course. But little Roman 1 is isn't relevant to this appeal, relates to a section, so to speak, a portion of the liabilities for which you will see participating employers have the entire responsibility of funding.
It is relevant, though, to the extent that it uses the word determines.
Yes.
In relation to the actuary twice.
Yes. I accept that. There are, as you have seen, lady, there are multiple uses of the word determine throughout this rule. And as you know, our case is that what process that signifies is different in different places, depending on the context, which helps to identify the process that the determination is part of.
Something that hasn't been touched upon, and I know you're still in your opening foothills, but I'd be grateful if somebody would give me some indication of the use of the word determine throughout the RPS, and whether it only applies to the actuary or whether it's used in other contexts.
You can do that. Little Roman 2, it is where it has always been, carrying the same number within this rule. There have been some minor changes to it. Essentially, the structure of 2 has remained the same. And you will see that at the beginning, the actuary has a determination to make as to whether the remaining shortfall is trivial. The multiplier for participating employer contributions shall initially revert to 1.5, and then the contributions of members should be increased in accordance with Rule 3B. So that's by reference to the future's joint service contribution rate. Then the contributions of the employers shall be increased in accordance with Rule 3A, so multiplying the members' contribution by 1.5, as determined by the actuary. And those words, as determined by the actuary, are the words that are in issue, give rise to one of the issues on this appeal. What does that mean? You'll see, if you read on, that there is a limit to the amount of combined 60-40 contribution that can be generated by this part of Rule 21.2 because of the cap of 130% of the participating employer's normal long-term funding rate. So that's its share of that long-term funding rate. The actuary determines what that actually is at the date of the valuation, and if the designated employer agrees to the cap being lifted, then the employer and the members will pay the higher rate, 60-40 pro rata. And there's an additional task, having done that and worked out what the total joint contribution in money terms will be, the actuary then has to take that amount and determine the rate and period over which those increased contributions shall apply. And having an initial amount already calculated for the total contribution required, that involves the actuary therefore determining a period, and the rate would then follow from that period. That's the way we say that works. Little Roman 3 is new in the sense that it wasn't there at the beginning in 1994. If I could invite you to look quickly at Bundle B 21. This is a very useful table, with thanks to the trustee team for producing it. This shows all of the changes to both the contribution rules, i.e. Rule 3, and Rule 21. If you...
Which page, Mr.
I'm so sorry, my lord. It is page 284. And the particularly relevant changes, which are the changes to Rule 21, start on page 299. And it's helpful because you can trace the amendments from here. The first box is what the rules said when it was annexed to the 1994 RPS order. There was then a change. I told you there was an amendment before the scheme was actually up and running. That's the 30th of September. There is a change, and we'll come back to that change in due course. It is a significant change to what was then Little Roman 3, but is now Little Roman 4. And the introduction of what is now Little Roman 3 was on the 28th of June 2006. It's page 302 for the start of the box, and the relevant part appears over the page, where you can see Little Roman 3 put in. And this was a decision by trustee to amend the scheme in order to cover the situation where there are no active members able to contribute they're not active members, so there are no members under an obligation to contribute, and therefore no possibility of the approach identified in 21.1 2 of a joint contribution being made anymore. We're not in that position at the moment in this scheme. There are still active members, but the trustee's case is that if the rule operates in the way that we say it does, then there is a serious risk, a high likelihood that active members will opt out of the scheme in order to save themselves having to pay significant contributions in a situation where their further benefit accrual may have been substantially, if not entirely, reduced under what is now 21(1)(4).
What's the increase which they would have to meet?
They would have to meet their 40% share of the total that is generated by 21(1)(2). That's the value of the shortfall for Rule 21 purposes. That figure is, let us say, 10 million. Subject to the cap under 21(1)(2, and certainly under the old BRPS, it would have been 60-40 between employer and members. It's not as much as that because of the cap, unless Atos chooses to waive the cap, which would increase its own 21(1)(2 contribution, but also the members' contributions. So they would then be paying 60% and 40% of my notional figure of 10 million if it were not for the cap. The cap, as I say, caps that, and that has the effect, and that's there for the employer's benefit. It can waive it if it wants, but it was introduced as a cap in the RPS. It was not present under the BRPS. It's part of the privatisation deal, we would say.
But the cap benefits both.
Yes,
because
it
they're
does.
because they're in
Lockstep.
step with each other.
Yes, exactly. It does benefit them both, but it has this effect. If 130% of the shortfall of 10 million is not 10 million, the next step in the rule is 21(1) little Roman 4. And if you go back to where we were...
Well, can we just pause it? There are only 29 members left. Is that right?
Active members.
Active members.
Yeah.
They're the ones on whom the burden falls.
Yes, that's the way that this scheme has always been set up, my lord. Back in the day in the BRPS, the burden of the entire shortfall falls on the employer and members in a ratio of 60-40. At the time that the scheme was created in 1994, there was a surplus in the BRPS. There were a huge number of active members. The railway employees effectively went into this scheme, the RPS section, and there were lots of active members. At that time, the position was not, or wouldn't have been, of concern.
But it was closed from the start to new entrants.
No, it closed to new entrants subsequently in 1999. Yes, thank you. In 1999. So for 5 years, new people came in, or could come in. Then they couldn't. So, and that's a key event. Closure to new entrants, because it means that you're not refueling, if I can put it that way, you're not restocking the active membership group with new people. And so gradually, as they dwindle, they take retirement, they leave service and move elsewhere. They are in a position where gradually the burden can and has got much greater. It's a problem for the employer, it's also a problem for the members. That is the way the rule works. We say, Malone Friend says that by reading some of the key parts of this provision so as to give the actuary a discretion to consider effectively on behalf of members considerations of affordability, value for money, collectability, that can be mitigated and the burden can thereby be taken off a potential benefit reduction and thrown onto the employer. We say that's not the way the rule works, but that's at the heart of the dispute and the debate.
How does it work? Suppose there's only one active member left, that it's assumed that he is still alive because his bank isn't refusing the payments, but he doesn't respond to letters or emails.
He's in employment necessarily if he's an active member.
Oh, I see. He's right.
We're not talking about pensioners who are at home or wherever they might be, receiving their pensions, or deferred members who've moved out of pensionable service and are elsewhere.
But if you're right, you may be right. We don't have the argument yet. Just looking at the practicalities, the scheme is going. The active members are all going to opt out within seconds of the decision, because otherwise they're, in theory, liable for, I don't know what, millions.
Certainly, I would have to accept that they will, and that would be the rational decision.
Yeah.
The way the scheme works relies on members taking that rational decision to opt out in order to ensure that they are not subject to a burden of that sort.
And all that's foreseeable, at least from 1999. That the day will come when there's almost nobody left.
Yeah, and we referred in our skeleton to the Independent Railways Pensions Committee that looked into this scheme in the mid-2000s and produced 2 reports in 2007 and 2008, where this is recognised as an issue, as a consequence of the shared cost and indeed benefit potential reduction aspect of the scheme. It's a time bomb in one sense.
But in the beginning...
No amendments to address that possibility were made in the years that it was foreseen, and it has, in this particular scheme, because of the size of the shortfall, produced this situation. The learned friend below, and to some extent the Chancellor, taking up the point, somewhat castigated Atos, my clients, for effectively trying to use this rule to procure opt-outs, and some evidence to support that accusation was said to be found in the fact that in the trustees' evidence, a number of other sections with other employers have managed to agree an arrangement under 21.1 STEM that doesn't involve causing members to opt out. But one doesn't know what the circumstances of those schemes were, how big the deficit was, how many members there were, etc., etc. The implication is that Atos is trying its luck. All the other employers have never thought that this is the way the rule works. On the contrary, we don't accept that at all. It's just that it hasn't been commercially either in their interests or necessary for them to take the stand that Atos has taken. And I'm very keen, as you might imagine, to ensure that my clients are not depicted in that way. There is a letter in the bundle. I won't take it to you because it take up too much time. It's a letter from Atos to the regulator, responsibly, I would say, raising the problem with the regulator and asking for the regulator's help. Atos wants to know what its legal rights are under the rule, so it can then start to consider what the appropriate way to fund the Part 3 deficit in this scheme is going to be in conjunction with the trustee and the regulator. But it's a very unfortunate state of affairs, but that is the position, we say, under the correct operation of this rule.
But Mr. Spink, two things, if you could help me. One of which is, when it was set up, there was a surplus. Is that right?
Yes.
In 1994-ish?
Yes.
And so there was probably a surplus when it was closed to new members in 1999?
That I don't know.
Okay. And then the other question is, please may I, before you go on, go back, and I'd like your help with little 2. And you've been giving the example of what if the deficit as determined by this rule is £10 million. But what does actually, before we go on, I think it is important to get in our heads and therefore know what this diminishing band of actives might have visited upon them. It's not £10 million, is it? It's increased contributions of 130% of the participating employer's normal long-term funding rate. So that's the cap. What does that mean? It means that you've got the £10 million and you've got to fund it by way of this increase in contributions up to this cap of 130% of the normal long-term funding rate. So that's going to work out at some sort of, and then we've got the 60-40, that's going to work out as some sort of high percentage. I'm just trying to...
High percentage of...
Rate of contribution.
Yes, on that figure. I don't have the...
No,
ability,
but to say,
quite
I think we were just, I'm just concerned that we were just proceeding on the basis of, gracious me, £10 million, that's £10 million that the employer and the members have got to provide. Actually, they would be faced with an enormous increase in rate, which would be very difficult. But we're not talking about numbers, pounds. We're talking about rate, which would then be determined over a period, and query the rate would vary according to the period. That's what we're talking about.
Yeah. Yeah. The key component, though, before you come to the rate, is what's the capital amount? Is
it 10 million? Then you've got to determine as an actuary how that works out in rate and period.
How you should,
but what would the, sorry, what is the normal long-term funding rate?
Exactly. It's the cost of future service. Yeah.
I was surprised at the use of that word, which is why I was trying to drill down into what the cap really meant and what 130% was. 130% of what? And it's the normal long-term funding rate, rather than going back to that definition that you showed us about rates to be paid, etc.
Yes,
so
but it's the same.
That's why I was a bit confused about what the cap was.
If you remember, the definition was that future joint service rate is the normal long-term funding rate.
Oh, they are the same thing,
yes.
Are they?
Yes.
Well,
shame they didn't say so.
Sorry, but what are we talking about?
Yeah, it's a slightly strange way of dealing with it, but that in the rule they use 130% of the normal long-term funding rate, but we know from the definition that we took you to earlier that is the same thing.
Okay. Thank you.
As the future service joint contribution rate, FSJCR.
Thank you.
Yes.
I think there was some evidence, I'm so sorry, we're really digressing now.
Yeah.
Have I got something in my head about it being 74%?
Exactly.
I just want to have it, the picture.
That is one of the percentages that appeared in the paper.
Yeah.
That was annexed to the chair of the trustees' witness statement. It came from the scheme actuary.
Yeah.
Sorry, 74% of what?
Yes.
May I help?
Please do. Yeah.
Sorry, may I help?
I'm so sorry to
No,
have done a
no,
hole.
it's absolutely right. It's helpful to a learned friend, obviously. I mean, we were talking about the 10 million. We'll put that to one side. If the employer doesn't agree to lift the cap, then the contributions are capped at 130% of the future service joint contribution rate. 130% of the normal long-term funding rate. That is 130% of the cost of the accrual of future service. Yeah? It's a measure which is not looking at how much of the deficit is attributable to past service. The cap is 130% of the cost of the accrual of future service. Now, the 74%, which your ladyship got from the evidence, can be picked up at paragraph 613 on page 236 of the bundle, in the actuary's note, B15236. And the 74% is the uncapped. It's 74%, sorry, B15236 is the uncapped.
I'm not standing up to interrupt. I'm standing up using my computer. Yes, no, you are. Thank you.
If it's capped. Yes. So if you'll see that at B15236,
Yeah.
you've got this is a statement that if the contributions of members, by reference to the 18.1 million shortfall in 2019, are uncapped, they're 74% of section pay, and the 1.5 multiple in relation to employers is 111%. Whereas, to help my learned friend, to complete my learned friend's submission, as it were, if you go back to 6.11, if my learned friend's client applies, as indeed they have, the 130% cap, then the respective contributions contract back to 13.36% and 20.05%. And that is the 130% cap applying to the normal long-term funding rate. And your ladyship asked for a little bit of assistance as to how the future service joint contribution rate is derived. That assistance is provided in the same document at pages 234 to 235, section 5, where the actuary explains how it's calculated.
I'm extremely grateful. Thank you.
May I just say one thing about that paper from Mr. Mason? We don't challenge the order of magnitude of the percentages that he put in his paper. There was no directive for expert evidence. This paper was just appended as a factual matter to the chair of the trustees' witness statement. We would be cautious. We would urge the court to be cautious about accepting precise percentages because we don't know how they're calculated. But the thrust of the matter is illustrated by these.
I'm very grateful. I just wanted to have the correct sense of what all this meant, rather than us just using £10 million as if they were going to get a bill in the post.
Yeah.
And could I also just ask whether somebody would just tell me what the employee's rate of contribution is at the moment? I'm sure you don't know right now, but I'd be grateful.
The footnote seems to say 11.68%
Well,
of section pay. That may be slightly
yes.
less of overall.
11.38%.
Yeah.
Thank you.
So yeah, exactly. And the that would rise on these illustrative figures to 13.36% if the cap is applied, and rather more if the cap
If
were
the cap
lifted.
If the cap is lifted, you get the completely ludicrous results shown in 613 and 614.
Yeah.
Thank you so much.
Of course, the offset, though, is that under the operation of the rule for which we contend, if that exercise does not result in making good the shortfall, in the sense required by Rule 21.1, the next step in what we have described as the waterfall of provisions within Rule 21.1 is 21.1.4. If you just have a look at that, you can see it in its up-to-date form in B. Tab 13, 219.
Yes.
And this provides that, again, unless the actuary determines that the remaining, that's remaining after 21.1.2, shortfall is trivial. There's still a shortfall after the increases of contributions under 2. The benefits of members in respect of future service shall be reduced, calculated on such reasonable basis as may be agreed between the employer and the trustee after considering actuarial advice, and which is consistent with revenue approval. If the employer and the trustee are unable to do so within 9 months of the signing of the valuation, the actuary shall determine the basis of reduction of members' benefits in respect of future service and shall notify the trustee and designated employer. It may be helpful to you to look at how that it evolved in the way that we did just now in respect of 21.1.3. If you go to tab 21 in this bundle and start at page 300. I'm sorry. No, the best way to start is on page. Lost it. 299, because that shows you the original version of the rule, and just at the top of 300, you can see what is now Little Roman 4 was then Little Roman 3, and the only method of what we say is the mandatory reduction in benefit for members being achieved is through an agreement between the employer and the trustee. I think it hopefully will be clear to you from our skeleton argument that we say that the words "on such reasonable basis as may be agreed" does not give them the power to not make any reduction at all, or indeed to do anything other than reduce benefits to the value required to fill the gap in the shortfall that still remains after 21.1.2. The reasonable basis is how do you go about reducing those benefits across the population of members? Which benefits do you cut to generate that value? And which members are affected in what different ways? And that has to be a reasonable basis. You're applying effectively a capital cut, and there needs to be a reasonable basis for spreading that amongst the members' benefits. The amendment to change that to something similar to that which we now have is on page 301, where you can see that if, in order to meet the situation where the employer and the trustee fail to reach the agreement that is required of them, the actuary will undertake the determination of the basis of reduction, and that means the same thing as it did when it was a matter for the employer and the trustee in our submission. Just standing back, we say the two key questions here are, although I know from a lady that the court will be looking at the use of the word determines in a number of places, but the key questions are the role of the actuary in 21.1.2 and in the second limb of 21.1.4. What does the determination in each of those places involve? We invite the court not to ask itself the question, what does determination mean? Because we say that it is thin on inherent meaning. It's a word that, depending on its context and depending on the process that it is describing the actuary's participation in, it may, in some instances, require, from the context, a discretion to be exercised, or it may, in another context, require something that's rather pejoratively being called a calculation role for the actuary. But in reality, in terms of working out under 21.1.2 what the total contribution is required to be, that is a calculation role. The actuary's judgment has already been involved in the valuation which generated the shortfall. And the actuary is now turning that into a contribution under 21.1.2.
I'm sure you'll be coming back to this. Would it be fair to say that the verb determine, as a matter of ordinary usage, normally connotes perhaps an outcome more than a process? It's a kind of synonym for decide, isn't it?
Yes.
Rather
I'm more than happy with outcome rather than process.
I mean, only as a kind of clue towards the general feel of the word. I'm not putting it forward as an exhaustive definition. Obviously, one goes to dictionaries for that.
Yeah.
But one's used to determine being used, as I say, as a rather slightly highfalutin synonym for just decide or fix or anything of that kind.
And in some cases, calculate. Perhaps.
Indeed, absolutely.
Yes, my lord, that's precisely what we say.
An outbreak of agreement sounds implausible.
The other feature that I've already mentioned, but I just flag it for you, is that the comparison under Rule 21 is on the asset side, the present value of future contributions, and on the liability side, the present value of all future benefits to be accrued after the valuation date, and those are added effectively to the current assets and the current liabilities. And it means that in our submission that the key driver for contributions under this rule is very different from the standard actuarial valuation, to which I've already referred. I won't go on any more about that. What shortfall means here is a difference between two large numbers, not a funding deficit, which is more of an accumulated overdraft that will have to be paid off. And Rule 21's response to that type of shortfall, which is the same shortfall as the BRPS conceptually, is to change both member contributions and potentially benefits. It's a scheme redesign to bring it back into manageable balance. At that moment, if after that has happened, if successfully, because there is sufficient value there available, a contribution increase under the cap plus any benefit reductions or without any benefit reductions provide sufficient value to achieve that balance there and then, should thereafter all of the assumptions that went into the valuation be borne out at the next Rule 21 valuation, the shortfall would theoretically be the same. Would not be there, because the new assessment would take into account the increased contributions from the previous valuation, which flow into the next valuation under Rule 21, and also any benefit reduction that's just happened. Of course, it's highly unusual that it does happen, and if, for example, there were, in between the valuations, significant opt-out of members, that would mean that at the next valuation there would be a shortfall again on the Rule 21 basis, and the scheme would have to be rebalanced through a change in contribution rate and or benefit reduction. And conceptually, Rule 21, if successful through the use of the tools that are mandated to be used, if they generate sufficient value, the shortfall conceptually under this rule is made good there and then. The position on a funding deficit assessment would be very different. And we say that that is patent on the face of the rule and follows from a proper construction of the rule and the mechanism that is in place. My next point is point 3, the protection order and the statutory scheme. Would it be...
Yes.
We didn't negotiate or discuss breaks for the transcribers, but
I was sent a timetable that had extraordinary precision.
yes, it did.
I've never seen a timetable which provided, for example, for 10:42 tomorrow being a critical point, and a 6-minute break is not much use to anyone.
That clock
First
is
of all, that
wrong.
clock is 10 minutes slow, isn't it?
fast. Oh, slow. No.
Slow.
We'll return at 11:30 by that clock, which would be 11:40 by my watch.
And mine.
Good.
Yes, it does. Not really. Yes. No. Yes.
Is everybody ready? Is everyone hearing?
Just thank you.
Yes, Mr. Spink.
So my next topic in this introductory section of my missions is the protection order and the statutory scheme.
Yes.
So we would describe the protection order as an overlay on top of the scheme rules. Why is that, and why does it apply? If you would be so kind as to have a look at, take your first look at the protection order, it's at B11, and I'm inviting you to look at Article 4, which is at 142 to 143. This is this is central to the existence of the RPS and any other what we would call Article 4 scheme. The key point to take from this is that this legislation, this statutory instrument, contemplated not just the RPS as a relevant scheme, but potentially others as well. And
Sorry, what, you said B11.
B11, 142 to 143.
Oh, sorry, B tab 11. Right. Yes.
I apologise, yes, tab 11. Any person who employs a protected employee shall provide an occupational pension scheme in which that employee may participate, and to which transfer value in respect of his relevant pension rights which he's acquired, other than any relevant pension rights acquired on the death of a protected person, may be transferred. I would rather not get diverted into giving you definitions of all the relevant terms. We can do as we go along if that's convenient. I'm trying to get the scheme identified, the status of protected person is something that you can find in Article 2, which is two pages earlier. No, I'm sorry, I got that wrong. Forgive me. Forget that.
Protected employee.
Protected employee
is defined on page
defined,
140.
yes, as a person who's that's under one. A person who's protected person by virtue of paragraph 5A of Schedule 11. You remember I mentioned to you that Schedule 11 is the schedule to the Railways Act 1993, and it's the source of the power to make the statutory instruments that are the protection order and the RPS order, and that is where many of the definitions are contained.
Page 113. Yeah.
Is your Lordship on page 113
Yes.
of the bundle?
Protected person.
Yep. That's where all or many of the definitions appear. If I can just flag up to you while we're on that page, if you go back to 107, you can see the definitions of existing schemes, which is a scheme for provision of pensions for persons with service in the railway industry, and which the Secretary of State by order designates as an existing scheme for the purpose of the schedule. The joint industry scheme means an occupational pension scheme that the Secretary of State may by order designate as the joint industry scheme for the purpose of the schedule, and that is the that's the RPS. And as your Lordship pointed out, protected person is defined in paragraph 5 of this schedule.
I'm sorry, I thought that the RPS was new scheme, defined at page 108. I don't think it matters.
But it's both. It's a new scheme, but it has the status of the joint industry scheme under the protection order, given that status. So the point to take from Article 4 of the protection order, where we were just now, is that if a protected employee is employed, the employer must provide a scheme in which the employee may participate, and to which the transfer value in respect of his relevant pension rights, also a defined term, which are transferred. Now, what Article 4 contemplates is the possibility of future transfers of employment, and therefore an obligation on the employee, on the employer to provide a suitable scheme for a protected employee. So the RPS, although created at the same time by the same minister under the twin order, the RPS order, is not potentially the only scheme. The paragraph 8 of Schedule 11, B10, page 119, identifies the people who have a right to participate in the joint industry scheme, which is the RPS. The effect of these various definitions is that a protected person will lose the entitlement to be in the joint industry scheme under Article 8. That's their indefeasible right if, without continuity of employment being broken or opting out, you cease to be in the employment of an employer engaged in the railway industry. That's paragraph 8.3c. Now, you would remain a protected person if that happened, but you would, and therefore you would be entitled to be provided with a scheme under Article 4, and that is the point that I'm trying to make. That the scheme under Article 4 contemplates the possibility of more than one, numerous Article 4 schemes. The place of the RPS in the statutory scheme, if you look at Schedule 11, paragraph 2, that's at B10 109. Schedule 11, paragraph 2. I'm sorry, I got my page numbering wrong. Forgive me. Yeah, that's creating the scheme. Yeah. The designation is under the order itself. Article 3. Yeah, it's B. 424. The establishment of the scheme is provided for in the Railways Pension Scheme Order 1994. And under Clause 3, Paragraph 3, the Railways Pension Scheme is designated as the joint industry scheme. That's what I was trying to get to. If again one looks at Schedule 11 for the next point, Schedule 11, Para 6 is a my numbering has gone. Please forgive me. Yeah, thank you. B10 page 114.
The powers of protection.
Powers of protection. This is the power to make an order vested in the Secretary of State for the purpose of protecting the interests of protected persons in respect of their pension rights. That's a general power to make provision. Paragraph 6.2, without prejudice to the generality of that, an order under that subparagraph may make provision for the purpose of securing A, that the relevant pension rights of protected persons are no less favourable as a result of any amendment of the scheme, transfer of pension rights, or any winding up. And they would have been apart from the amendment, etc. B, that a person who's a protected person is not prevented otherwise than by reason of either of the following events. That is to say, 1, continuity of employment broken, or 2, he voluntarily withdraws. Note that phrase. This would appear to be the power in part, at least, that provided for Article 5, which we'll come to in due course, which is the subject of the final issue in our appeal. The key protection concept is in Article 4 of the Protection Order. So we're now in B11. That's the obligation to provide a scheme, shown you already. That includes, but it's not limited to, the RPS and the SCA employers have no choice over how to comply with Article 4. Article 5, as I said, is subject to part of this appeal. It's about participation and acquisition of relevant pension rights. And you can see it on page 143. None of the persons mentioned in paragraph 7.2 of Schedule 2, Schedule 11, that would include an employer or a trustee, shall prevent a protected employee from participating in or B, acquiring relevant pension rights in that scheme. And to flag up, it is this provision which the trustee says prevents Atos from lifting the cap, albeit that it is permitted to do so under the terms of the rule, Rule 21.1.2, if the consequence of that is that it leads to member opt-out. It is said that that opt-out is engages 5B because and A because the relevant member is no longer participating in or acquiring relevant pension rights in that scheme once they've opted out. Article 6 deals with scheme amendment. There are requirements and controls over amendments. And then Article 7 on page 145, an important article that we'll have to look at closely. It's headed contributions, and it is a funding article in the protection order. The other articles that we've been looking at are somewhat different in nature. You will see in 7.5 that there is a requirement that when the trustees are exercising a power, which could be a joint power with the employer, to increase contributions that are payable by a protected employee, or to reduce benefits which are payable by the protected person, they shall not exercise their powers in relation to that unless the increase or the reduction is made in the circumstances and manner in which it could have been made under the designated scheme. Designated scheme is the BRPS, and so it takes you back to the BRPS for the purpose of that comparison, and the scheme actuary has, within a period of 6 months, advised the trustees that it may or should be made. Learned Friend relies to some extent on Article 7.5 as supporting his general approach to the discretion of the actuary. You'll notice that the requirement is for advice from the actuary to the trustee in the exercise of their power. If, for example, under Rule 21.1 STEM, the trustee and the employer were to agree an arrangement which either increased contributions for the members, protected persons, and or reduced their benefits, this would be engaged, and they would have to take the kind of advice that is noted here. We say that the key indication that the protection order was building in shared cost changes to contributions to meet shortfalls and changes to benefits is at Article 4.3.
Article 4.3.
Yes, 4, going back up.
Okay.
The purposes of making any determination as to whether relevant pension rights in a scheme are more or less favourable than the rights in the designated pension scheme, BRPS. Again, there's that comparison. Regard shall be had to the provisions of the schemes as a whole and the circumstances and manner in which that designated scheme, BRPS, permitted increases in contributions or reductions in accrued or accruing benefits. It's an explicit reference back to the potential for increases in contributions or reductions in accrued or accruing benefits, which was a feature of the BRPS. So that's important in understanding the scope of the protection order, we say. And it does not follow that because an Article 4 scheme is an Article 4 scheme, that it has to offer benefits or have contribution rules that are the same as the RPS, which was the paradigm when it was created in 1994. The protection order contemplates that other arrangements might exist under those schemes, but the key and critical test is whether the rights that that other scheme gives protected persons are no less favourable than they were under the BRPS, because that is the benchmark, certainly the floor that the FLOOR that is contemplated by the protection order. My learned friend said below, and it's true. That doesn't necessarily mean that the protection order doesn't provide something more than no less favourable rights. In principle, that could be the case. The question is whether it does in a relevant way for the purposes of this appeal. There is a point here that I want to just make about the place of the RPS in relation to the protection order, and in particular to what extent can scrutiny of the RPS and its provisions elucidate the purpose and scope of the protection order, especially Articles 7 and 5. As we know from the provisions we've looked at, the RPS, including the SCA section, is the scheme set up, or was the scheme set up by the Secretary of State through the RPS order and its schedule to comply with Article 4 requirement to provide a scheme. There is then, within the pension trust for the RPS, clause 7H, and if I can invite you to have a look at that, that's at B12186.
So we're leaving the
We are leaving the protection order for now. Yes, my numbers are back in sync now. Where in relation to a protected person the provisions of this pensions trust or the rules do not satisfy the requirements of the protection order, then the pension trust and the rules should be operated in relation to that person in such ways to ensure that they do comply with that order. Something similar was in place in the pension trust at the outset, annexed to the RPS order. We say that this and the surrounding circumstances, namely that the Secretary of State created the RPS as the joint industry scheme at the same time as creating the protection order, that this demonstrates, along with those circumstances, that the Minister's purpose was for those rules, the SCA rules, annexed to the schedule, to comply with the protection order. And that clause 7H is included as a fail-safe in case there was any unappreciated gap present. It's not, contrary to the approach that the learned judge, the Chancellor, took at paragraph 105 of his judgment, an indication that the protection order was intended to confer additional protection, and if I could show you that one paragraph feeding into one other in the judgment, it's at A242. The protection order, this is paragraph 105, is clearly intended to provide protection to protected employees in addition to that provided by the Pension Trust and the RPS, hence the terms of clause 7H, which made it clear that if the Pension Trust and the rules did not satisfy the requirements, they were to be operated in a way so as to ensure they did comply with the order. Well, that much is correct. That is what the 7H said, but we disagree with his the conclusion that he's drawn from that. None of that would have been necessary if the protection order was not providing protection, none of that being clause 7H. And we, again, dissent from that for the reason I gave just now. And that's an important indicator that the intention was that the RPS would comply with the protection order, and that can assist in delineating or helping to delineate the scope of the protection afforded under the protection order itself. You can see that my submission to you that the Minister's purpose was for the rules to comply with the protection order is also demonstrated by the final response to consultation prior to the legislation coming into force, the so-called Montague consultation. Montague was a civil servant, the Deputy Secretary in the Department of Transport, the relevant department. This is at B318. And I would invite you to consider, first of all, page B322. I'm taking you straight to the bit that's relevant to this. There's a fair bit in this
B3
letter.
B tab 3 page.
B tab
22.
3, take page 22.
Right.
I'm passing over the reference on page 21 to a government guarantee. I'm going to members' transfer rights. You'll see, and may I flag up before I take you to that, the date of this document is the 31st of March 1994, which is only 2 months before the Minister put into effect the protection order and the RPS order. So this is right at the end of the long process of discussion and consultation, and Montague is reporting on the outcome of what has happened, and you will see that at the bottom of page 22 he is sending the consultees a bound volume containing the pension trust, the rules of the shared cost arrangement, and over the page the establishment order for the RPS order, and the pension protection order. It describes it as a tall order to get comments back in the time available after that. But that is, it makes it clear, it's a package. And we suggest that it's would be extraordinary if the relevant minister had built into the rules some gap which only the protection order could fill of a substantial nature. If you go back to the top of page 22, you can see that there's a specific reference to members' transfer rights. Their accrued past service pension rights should be transferred to their new employer's no less favourable section. So you can see he's using the language of the protection order, and again in the second paragraph, no less favourable. And finally, above the word timetable, the heading timetable, there's a paragraph talking about the indefeasible right, which is also protection order language. So we would submit that it's clear that the pension trust and the rules was intended to comply with Article 4 of the protection order. And the Minister settled the terms of the railway pension scheme knowing that the protection order would apply to it. And what does that mean? What expectations could that create for the construction of the protection order and for the RPS? We would submit that any proposed construction of the protection order which would require significant interference with or overriding of the basic structure set up under the RPS at the same time the protection order was set up needs to be scrutinised carefully to assess whether the suggested justification by whoever is proposing it for that conclusion is justified. We would submit that proposition would be likely to be wrong in the circumstances I've been outlining. This applies, we submit, in particular to the second main issue in this appeal. The first is the construction of Rule 21.1 and whether there is a discretion in the actuary at little Roman 2 and little Roman 4. The second, which is what the Article 7 part of the case boils down to, is when Article 7.1, to quote the Chancellor, kicks in, and there is a question, and indeed it was answered by the Chancellor in favour of the trustee, which is that Article 7.1 kicks in and interposes itself after 21.1.2, but before 21.1.4, so as to enable the actuary to settle a schedule of contributions under Article 7.7 of the Protection Order, which imposes on the employer an obligation to fund through Article 7.1 the balance of the Rule 21 shortfall not met by the increased contributions under 21.1.2, and so dispense with the operation of 21.1.4 and avoid any reduction in benefits. And we say that the submission that I've just made about it being the intention of the RPS that the structure within the intention of the Minister, the structure within the RPS, in particular what we're talking about here, the funding rule, the contribution rule, would comply with Article 7, with the Protection Order, and would not be expected to be interfered with in the way that is being suggested here by Article 7, because if that had been the intention across the two sets of statutory instruments, why didn't it say it in the rules?
Mr. Spink, I'm sure you'll be coming back to this, but I mean, one answer to that could be that it's very easy with hindsight to spot a black hole, as it's been referred to. But back in 1994, when the schemes were all, there was lots of surplus, nobody was probably really directing their minds to the kind of situation we have now. Is not the whole point of having a backup or fail-safe that it will fill any gaps which may have been inadvertently left? And if it's a funding gap, well, what on earth is to stop it coming in at that point?
Sorry, my lord. We don't dispute that the effect of Article 7.1 is to fill a gap. The question is, what's the gap?
Well, why? The whole point of a general provision is it fills any gap that may arise.
Yes,
I mean, that's why
but
it's
there isn't a gap that arises at the 21.1.4 stage, or after the 21.1.2. There is a provision in the rules which, under the reading of the rules, is intended to happen and take effect. And so that's not a gap. The gap that Article 7.1 can fill is the gap that exists if, after the operation of 21.1.4, there remains some shortfall, my lord. And that's the gap that it can fill under our option B, as we called it, for Article 7.1.
I see.
That's not, that point isn't disputed between us, that it will fill that gap. The question is whether it interposes itself into the rule and changes the operation of that rule after 21.1.2 or after 21.1.4. I just, because I've said that we agree on that general outcome, that's the gap after 21.1.4. Under option B, that is the consequence of option B. I want to make it clear, though, that I don't know what the trustee says the process would be that the actuary would actually undertake to assess how to fill that gap, what approach he would take in terms of assumptions and so on. That's not something that it's been necessary for the trustee to identify in its case, and it's not somewhere that it is necessary on this appeal to go, because it's not a question on the claim form, as to how the actuary should undertake his Article 7.1 gap filling role, if it exists, and if he has to undertake it. And that is trespassing dangerously into Part 3 territory, which is why I flag it up, and why I've reserved my position in simply agreeing entirely with whatever concept the trustee may have, which isn't defined, for that gap filling role. But the principle that Article 7.1, if it's option B, will fill the gap that the rule cannot fill, is accepted. The point of difference is that the rule does provide for a filling of the gap after 21(1)(2), and what Article 7 cannot do is override that or interpose itself. And my learned friend doesn't mind really whether it's after 21(1)(2) or before, but that's because he is assuming that it's right that the actuary has a discretion. If the actuary has a discretion under 21(1)(2) and 4, then he's got a means of controlling the benefits that this scheme offers to members going forward, and controlling the contributions that they pay. In which case, it wouldn't on that basis matter. I understand that, but that's the reason he suggests that he's relaxed about it. If we are right and the actuary doesn't have a discretion, then it does matter very significantly whether it's before or after 21(1)(4). My next point was the RPS scheme design. Why was it created in the way that it was? It's at this point that might be helpful to look at the Rule 45(5) of the BRPS. If the actuary reports that there's a shortfall which is not attributable to preserved benefits, so this is the equivalent of 21(1)(2), a shortfall attributable to preserved benefits would be 21(1)(1). Such shortfall shall be made good in the following way. The employer and the trustee may agree within 3 months of the signing of the valuation arrangements effected through amendment to the rules in accordance with Rule 46 for 1, the payment of additional contributions, or 2, the reduction of benefits, or 3, a combination of 1 and 2, as such other methods as the principal employer and trustee may agree to make good the shortfall. If no agreement is reached, the actuary shall, as soon as possible thereafter, and in any event no later than 6 months, having consulted, determine the amount of such rate of increase in contributions, member and employer contributions, as is necessary to make up by breaking that down into a rate over a particular decided time. And that is a matter to be determined by the actuary. And the contribution rate shall be divided 60-40. And that is the principal part of that rule. So, potentially benefit reductions which are not restricted to future service but could have included accrued, which is quite a significant matter for any member, not just to stop accruing but to have some of their past service accrued right taken away from them, to calculate, to plug the shortfall, to make good the shortfall, and then he has some discretion about the rate and period that amount shall be payable through and for.
Mr. Spink, what do you mean by discretion there? He has some discretion, you say?
He has, in determining the rate and period, he can use his judgment as to what the appropriate period should be. Should it be, if it's significant,
So
it could
use
be
use his judgment, absolutely. Okay.
use his judgment on that. Certainly.
Yeah.
And one would expect, in a scheme of this sort, particularly where one was effectively committing the members to significant contribution increases, that you'd spread that out over as long a period as possible, so as to reduce the rate to the minimum amount per month or year.
And in the rule, in 45.5, it says when he's doing that, he consults the trustee and the principal employer, which is why I asked you what you meant by discretion.
Well,
and I think the answer is using his judgment, having consulted.
Having consulted, yes. Yeah. It's for him to make that decision, to use my Lord, Lord Justice Henderson, if I may refer to your Lordship in that way. He makes the decision, having consulted. It's a very different decision than the quality of the discretion that it is contended the actuary has when it comes to Rule 21.1.2, where he is, the parameters are relatively limited here for him, but under 21.1.2 and 4, according to the trustee, he has an unfettered discretion to take into account whatever matters he thinks are relevant, particularly how much he thinks members can afford to pay. And that's a very different sort of discretion to the judgment that he has to form here. And you've already seen, because I've taken it to you, I've taken you to it, that the equivalent in 21.1, there are strong analogies in terms of the shared cost arrangement, the increase in contributions, the way in which benefit reduction works is in a different place after increases in contributions. The principle of potential benefit reduction in order to fund the shortfall is similar. The other aspects of the design of the RPS, just to flag up, as my lady has already reminded me, actives only. The pensions and deferreds went into the A and B sections, and there was a Crown guarantee for the closed sections. As far as Article 7 is concerned, the question is whether in terms of design, did Article 7 turn it from a shared cost arrangement, as it undoubtedly was in the BRPS with no balance of cost obligations, into firstly a balance of cost scheme, and also one which doesn't respect the waterfall in 21.1.2 and 4 because of the interposition between the two stages in that process brought about, it is said, by Article 7. The claim form and the issues, I don't think I'm going to need to take your lordship, the court to those. The claim form is at A1.2. There's a list of questions at A1.5. The issues I think I have highlighted, but in principle under Rule 21, what does it mean to, quotes, make good the shortfall? And what does it mean for the actuary to determine 21.1.2 increases and 21.1.4 reductions? What does the protection order, Article 7, add? I've identified exactly what the issue there is, and there is an issue in relation to Article 5. the Chancellor's decision, in summary, is that in relation to Rule 21, there is no comprehensive regime provided for under 21.1.2, and there is a discretion at the two stages that we, 21.1, and there is discretion at the Little Roman 2 and Little Roman 4 stages. And Article 7 imposes a freestanding balance of cost obligation, which kicks in at the stage that I've identified. I'm now going to turn to deal with the grounds.
Yes.
If I may. And these can be found in bundle A. The grounds for appeal start at bundle A, tab 5 at page 78. What I propose to do is give the court my principal submissions by reference to the grounds, so that you can see how those submissions are directed. Ground 1 suggests that the Chancellor erred in deciding that Rule 21.1 was not intended to create a comprehensive regime for eliminating shortfalls within the Atos section, construing the rules without reference to the context established by the protection order. I think probably what we meant in the parentheses was construing the SCA rules without taking into account the effect of the protection order. But in any event, the submissions on ground 1 break into 4 sub-grounds: 1A, B, C, and D.
Is this going to follow your skeleton or depart from it? I'm really asking, do you want us to write down what you're saying now?
Well, it's not following my skeleton
all right.
closely. Okay. It is the grounds are dealt with in out of order in various parts of the skeleton. So I'm
okay.
addressing you alongside my skeleton, if I may.
Right.
I don't want to. You've read my skeleton, and I don't intend to go through it paragraph by paragraph or section by section. I'll refer to it where necessary.
Right.
Our case on ground in relation to ground 1A, so that you understand what we mean by exhaustive. We say that Rule 21 is exhaustive in that the waterfall is compulsory and always has been. If a shortfall is not made good by arrangements under the STEM, 21.1.2 mandates contribution increases up to the cap. If the shortfall is still not made good, 21.1.4 mandates future service benefit reductions, potentially to nil. That's what we mean by an exhaustive regime. Clearly, there are potential gaps that can arise, and in that sense, it's not fully exhaustive. But the intention behind Rule 21 was to make good the shortfall. That's the task that it identified the shortfall, and it set a task to achieve to the extent feasible, deploying the tools that were there. And the test of whether the shortfall is made good or not, I've already dealt with. It is made good if the value of the contribution increases and or the benefit reductions equals the value of the shortfall at that time. And it's as simple as that in terms of making good the shortfall. It's whether or not it's made good is something that has to be capable of objective assessment, because, as you will have seen in the rule, you only move from one stage to the next if there is a remaining shortfall. So the actuary at each stage has to be able to identify whether the value that has been created out of the stage that has just been completed is sufficient to make good the shortfall, or if there's a remaining shortfall.
Of a more than trivial amount.
Of a more than trivial amount, my lord, yes. Thank you. So the process of making good shortfall is one of doing what the rule requires, not one of taking steps with the goal that the shortfall will, in some point in the future, be made good by the consequences of those steps. We say that's clear on the rule linguistically. The rule doesn't direct the actuary or anyone else to increase contributions with a view to making good the shortfall in the future, but they have to take mandated steps by making, by way of making, or so as to make good the shortfall in the immediate sense that I have identified. I've said that arrangements or increases that do make good the shortfall must be capable of being identified objectively, and that's a strong pointer that a shortfall is not the same thing as a classically conceived funding deficit, but something different. Shortfall, for the purpose of this rule, is something that you can tell objectively whether it has been made good or not. That is what we mean by ground 1A. Ground 1B includes 1B2, which is the, as we put it, significant irregularity in the Chancellor's judgment at paragraph 95 of the judgment, which is at A2. Page 40. In that paragraph, he stated that Atos had accepted that the words "so far as practicable" should be read into the provision, and then he goes on to say that once they are read in, that necessarily involves the conclusion that 21.1 cannot be an exhaustive regime for eliminating the shortfall, since one of the ways in which it will not be practical to do so is if issues arise as to affordability. In other words, the word "so far as practical" connote that the actuary has a discretion as to what practical steps can be taken to reduce the shortfall. For your reference, we deal with this in our skeleton argument at section G, which is paragraphs 59 to 65, starting at A9119. What I would simply say, by way of oral submission in expansion of that, is that the concession identified by the Chancellor hadn't been made in the sense in which he took it. It is true that in our manual, this is an appendix to our skeleton argument at the trial below, which was an attempt by us as lawyers to identify what the rule on a proper construction required to be done at the various different stages. At note 10D,
Can you give us the page? Or?
B2280,
B22
It's B20.
B, tab 20,
20.
yes,
Thank you. At
2. The note starts at 279 and goes over to 2880. It's paragraph 10.
I'm afraid I'm lost. I thought you were telling us to go to tab 22, which begins at page 309 in my book.
No, I'm sorry, I said, well, I must have misspoken. I'm sorry.
I may have misheard equally like.
B20.
Right.
Defendant skeleton argument.
Okay, thank you.
Yeah. This is an appendix to our skeleton argument. This is an extract, it's not the whole thing. It was suggested that it amounted to, in effect, an actuarial treatise, but that's not what it was. It was intended to identify, by way of construction of the rules, how the rule operated. The point that arises in 10 is that on 279 in 10, we identify a circumstance in which Rule 21 will not, in the relevant sense, mathematically make good the shortfall disclosed by evaluation. Because if 21.414 is engaged and the value of the benefits reducing future accrual to nil is less than the present value of the shortfall, then you won't have made good the shortfall. And then over the page at D, we comment further on that. Even though mathematically part of the shortfall may not be good in the may not be made good in the situation contemplated in C above, it's nonetheless necessary to give proper practical effect to Rule 21 to treat the operation of 2 and 4 as having made good the shortfall resulting from the rule's valuation. This is because the action envisaged by Rule 21 to make good a shortfall has been taken to the maximum extent available under the mechanism of that rule. It would not be consistent with the purposes of Rule 21 to preclude any action being taken under the rule to reduce the shortfall disclosed by the valuation just because it's impossible for it to make good the shortfall entirely. Accordingly, it submitted that the words in Rule 21.1 which read the shortfall should be made good in the following way should be interpreted as meaning the shortfall shall, so far as practicable, be made good in the following way. And then the key bit, but with the understanding that the only way in which practicability could prevent the shortfall being made good in the relevant sense is if in fact the present value of benefits reductions is exceeded by the present value of the capped shortfall. So it expressly excludes that phrase, perhaps not as well phrased as it could have been, so far as practicable, expressly excludes on our side any concession that should be interpreted as meaning that there was the sort of discretion that the Chancellor intended for and found to be present on the basis of that concession at 95.
Would it be fair to say that the meaning you meant those words to have would be to the maximum extent legally possible?
Yes, exactly.
I mean, that would have been rather clearer.
It would have been clearer. No, I accept that. But
Yeah.
read in context, as your Lordship has done,
Yes.
you can see what it is intended to mean.
Well,
And it was my learned friend took the Chancellor to this passage in our skeleton to try and build on it precisely what the Chancellor then accepted.
Yeah. The odd thing is, he seems at some points to have treated it as though it were actually part of the text he had to construe.
Yes.
And that can't be right,
No,
because
it
it's
can't.
just part of a submission.
No, exactly.
I mean, it's not as though there's any question of rectification or the
No.
rule being rewritten or rather supplemented with something that should be there but wasn't. So it seems to have gone off on a curious tangent in that respect.
I respectfully agree, in his reasons for refusing us permission to appeal, he said at paragraph 3, I'll give you the reference, but I don't think you need to go to it unless you wish to see it on the page. I'll read it to you. Tab 4, page 57. He said in his reasons for refusing us that he had concluded only that it was common ground, which it was, that those words were to be read into the provision, with the meaning to be ascribed to them being a matter for the court. It's the same.
that seems
That
a bit
doesn't-
heretical, if I may say so, with the greatest respect.
I agree, and friends try and make light of it in the sense of saying, well, he had lots of other reasons, and he did have other reasons for holding that as discretion. But we do say that error was influential because we say the Chancellor thought it gave him a shortcut. You can see that in 95 to the answer to the main question in the case. That's ground 1B. I'm not going to say any more about significant irregularity. You have my point. Ground 1C. The Chancellor erred in failing to construe Rules 20 and 21 as requiring the Atos Section to be funded according to a prospective benefits method. With the result that the shortfall disclosed by the valuation under Rule 21 would be made good by the mere fact of making alterations to the future contributions prospectively payable to the scheme and to the future benefits prospectively payable under it. According to a prospective benefits funding method, whether subsequent actuarial experience conforms to the assumptions used in the valuation is irrelevant to whether the shortfall disclosed by that valuation has been made good. What we say about this point is as follows. We are not suggesting that this ground of appeal stands or falls on whether, as a matter of actuarial practice, it is correct or not to describe the method inherent in the rule as a prospective benefits method. That is a label which we put on the method that I have described to you, which you can see from the rule itself. And it is a debate that, with respect, we don't need to have, because my case is founded on what the rule says, not on whether, strictly speaking, it is a prospective benefits method. The reason that label was used was to distinguish it from the more conventional deficit accrued approach. And you can see, just by way of example, in one of the papers that are in the bundle, in bundle B, at tab it's in the authority. Tab 29. This is GN 26. It's a guidance note, Board of Actuarial Standards, 1996.
Sorry, so which bundle am I in? It's not
Bundle D, it's the authorities bundle.
D, thank
Yes.
you.
in the authority bundle by agreement after some lengthy discussion about where it should go, which fortunately my learned friend was able to cut through.
Bundle D, file 1, 2, 3 or 4.
Bundle 4. Keep telling me that, please. This is recommended practice to actuaries, 1996. It is just after the creation of this scheme, but it's contemporaneous in the necessary sense. And in any event, it's simply to show you what a prospective benefits funding approach may look like. And if I could invite you, it's a series of definitions to guide an actuary in his task. There is a description of the accrued benefits funding method on page 845, which I highlight only by way of contrast with what's coming shortly in terms of a prospective benefits funding method. Paragraph 3.1, accrued benefits funding methods are a major category of funding methods in which the actuarial liability for active members is based on pensionable service accrued up to the valuation date or to the end of the control period as appropriate, and the control period is defined just above as the period over which the standard contribution rate which we paid in the future to cover future service is calculated by reference to the control period, normally 1 year or more. The point is simply that is a past service deficit assessment combined with a stream of standard contribution rate going forward to meet future service accrual, and that is a fundamentally different approach from what we have in our rule, and what we have in our rule is more like prospective benefits funding method at page 847.
But this is all just what you say is the effect of imposing, as you would say, Article 7 into Rule 21 after little 2.
No. This is nothing to do with Article 7 at this stage.
So why do you say that the Chancellor erred in the way he did? Where is it in his decision? Where did he get involved with this?
He
I
well,
humbly say I don't understand.
this is about construction of Rule 21. It's nothing
Yeah.
to do with Article 7.
No, but I just don't understand why we're talking about different methods. I just need to see where it slots in.
It slots into my submission that the rule requires a certain series of steps to be undertaken, and those steps involve trying to make good a shortfall in a particular way
Yes.
that isn't consistent with an accrued approach and is consistent with a form of prospective benefits funding method. We don't need that label. It was at the core of our case that it was possible for the actuary to determine at any point in the process whether the shortfall had been paid or been made good.
You say it's immediate, he can tell. That's your point. But I don't see that the Chancellor made, and he wasn't interested, he didn't address this, did he?
Well,
And so I don't understand how it is a sub-ground and and how it fits in, which is why I was just
Okay.
wondering
Understand.
whether it was because you said he had interposed Article 7 in a way that you consider to be impermissible, that he changed the whole structure of the way that the actuary was going about things, which was contrary to the rule. But you don't say that.
No, I don't say that.
Okay.
May I?
So I've just
Yeah.
confused.
I'm sorry. May I come back to that point, please?
I'm sorry to hold things up. Maybe it's just me. Can we go back to Rule 21 itself?
Yes.
How does one ever get to 21.1.4? There are only 29 active members still in the scheme, and as you've accepted, if the Chancellor's decision was wrong, 29 will be advised immediately to give notice, so that then there will be no active members in the scheme. And that takes us to subparagraph 3. What happens then? Where there are no members in the section, contributions of participating employers shall be increased.
It's agreed between us that if at the relevant valuation under 21.1, 2 and 4, the outcome of that, on our case, would be a decision that current active members will pay the increase under 2 and going forward will not have their benefits continued.
Yes.
They are still active members at that point. Just because they're not earning benefits, they're still active members. They're in pensionable service, but it is for them to opt out.
Yes.
And that the effect of them opting out would then be considered at the next valuation under 21.1. It doesn't automatically engage 21.1.3 at that point in time because there are still members in the scheme, and although at some point not far in the future they are likely to opt out, that will be taken into account at the next valuation because they are in the scheme at the time that the rule operates.
How much notice do they have to give to opt out?
They give 1 month's notice, we understand. It says, okay, well,
It's Rule 16, isn't it?
yes, but it doesn't specify what the notice period is. It says, as the trustee shall determine, and we were told previously that that was 1 month. But if it's nothing, if it's no period of notice, and if Rule 21.1.3 is automatically engaged at the end of the 21.1.4 process at the same valuation, then 21.1.3 would have the effect of making Atos, the employer, pay contributions to plug the gap left by the increased contributions under 21.1.2 and the benefit reductions failing to make good the shortfall for 21 purposes. So that would be the position.
Sorry, the benefit reductions are in
21.1.4.
But why do you go to 4 before
Because
3?
It's agreed that 3 was inserted at 3, probably not very sensibly. It should have been inserted after 4, but it doesn't really matter because it tells you that it isn't engaged in the waterfall at this point in time because there are still active members.
is it a timing issue as far as you're concerned? You're saying you have the actuarial valuation which throws this up. You don't need to do 1 in this circumstance. You go to 2. You go through 2, and you say naturally you go straight to 4 because it says unless what's left is trivial, then and there's still a shortfall, then you do 4. But and therefore, is it a timing issue also in the sense that you say there is no stop on the road for them all to give notice and for it to become 3?
Yeah.
Because if there were no members, you'd start at 3. You wouldn't do 2 and 4.
Yes, exactly.
And if there are members, you do 2 and 4, and you would say there's no stop on the road, there's no time, put it that way, because you have to do 2 and 4. And then if, as a consequence, they all leave and you're in 3 territory, then that has to be dealt with at a different time.
Yeah.
That's what you're saying.
That's what I'm saying, and that I think is actually common ground between us. Because part of my learned friend's case below was that 2113 couldn't come to the rescue as part of that valuation while there were still active members. And it might be some time before there was another valuation. We don't necessarily agree that it would take very long to have another valuation and take account of that a few months down the line and engage 2113, but we recognise that there is a timing point, and that's also recognised and accepted by the trustee, which means that there is at that valuation, because the actuary is required to undertake the steps in the waterfall in whatever way the waterfall tells you he or she has to do that. But at the same time, Article 7 is engaged because there is an increase in contributions being mandated by the Rule 21.1 valuation. And so at that point, when the contributions are being increased and or the benefits are being reduced, the actuary will need to do an Article 7 schedule of contributions. That's Article 7.7. The trigger for that is either the triennial valuations or it could be triggered by the 21.1 process. So, my learned friend's point, with which on my option B I broadly agree in terms of gap filling, is that Article 7 is engaged as part of that valuation process, whereas Article 21.13 isn't. That's your timing point, my lady. And Article 7.1 requires the actuary to assess what additional contributions need to be made by an employer to make sufficient provision, we'll look at the wording in due course, for the pension rights that have accrued and are accruing.
And the difference between you is, and we'll look at those words, and I look forward to that, but the difference between you is you say you gallop along the road and you gallop along through 2 and 4 before you get to 7.
Yeah.
And Mr. Green says you stop for a moment after 2 before you get to 4.
Yes, that's what the judge, the judge didn't articulate it in quite that way, but that was the result of the judge's decision on that point. I think that I'm hearing from behind me that, reminding me that clock is slow.
That
It
clock
would
is
now be a
indeed
convenient
slow.
moment.
Yes. And sorry,
Sorry, my
just,
lord.
just one more question before we break off. Under 21.14,
Yes.
the benefits of members in respect to future service should be reduced.
Yes.
But that's only active members.
Yes, it is.
So if there aren't any active members, that achieves nothing either.
No, but they're still active for the purpose of this process.
The 29.
Yeah. Yes, they are. They are.
Well,
They
that's not going to save anybody much, is it?
Well, maybe not, but the process is will save something, and that's what the rule requires to be taken into account.
So the 29 people have zero accrual benefits because the deficit wipes them out dozens or hundreds of times over. And then what?
Well, they leave if they choose to opt out.
Yeah,
They leave pensionable service.
yeah.
They the rational decision is to opt out because you're not accruing any further benefits. And if you become a deferred by opting out, you then, in fact, get a better rate of return on your deferred pension rights in terms of revaluation, which is at a higher rate than what you would have on your accrued rights if you stayed in pensionable service, where the value of your accrued rights increases by reference to a salary link, but there's a pensionable pay freeze, so the salary link is not worth as much as revaluation is. So there's actually, at that point, if you're not accruing further benefits, a rational commercial reason for opting out, as well as not having to pay any increased contributions, or any contributions at that point.
And then whether it's under little 3 or at a later date, or whether it's at little 3, the employer picks up what the tab is.
Picks up the tab, exactly. Yeah.
So it's all a question of after little 2 whether the horse stops or not.
No, well, with that in mind, we'll break off now. We'll resume at 5 to 2 court clock time, 2:05. Anybody else's watches time. And we stop by 3:30 this afternoon.